Good morning, everybody. My name is Abhigya Ori. I am from Jyoti Vidyapeeth University, Jaipur, and I work as a faculty of Law and Governance in the university. So today what we'll be seeing is the Contracts Act. It is one of the most basic acts of law, and this comes under the bread and butter acts of the law. The bread and butter acts of the laws are the laws that you need to know or you need to have the knowledge of for basic survival. Like if you know these laws, the survival in the legal industry for anybody becomes simpler. So now what we'll do is we'll see the introduction of the Contracts Act. Okay. So the contract, what is a contract? A contract in a layman's term, if you're not going by the section 2 definition term, in the layman's term, it is basically an arrangement between two individuals. Okay. It forms a legal relationship between two individuals that is mostly which is related to trade. So when two individuals decide to work together, trade related, where money is involved and they form a legal relationship with each other, they are said to be in a contract. So now what happens is, this has been going on since time immemorial. People have been working together, forming trades, forming transactions together since time immemorial. But as we know, initially there was the king's law, which means that whatever the king said or the word of the king was the law. So whenever there was a dispute in ancient times regarding a contract or regarding an arrangement, which we can put in the definition of contract, whenever there was a dispute regarding it, people would go to the king's house or the king's court, and whatever the king or the king's men that he has appointed in his name would decide would be the final verdict, would be the final law as to how the dispute has to be resolved. After that, after a point of time, we developed governances, we developed a different kind of communities. We realized that the king's word cannot be the ultimate law in a situation. So what we did was we formed democracy. Now the entire world does not work according to democracy, but a lot of countries in the world in the present scenario work according to this situation or the democracy. So when democracy was formed, what we realized was that we'll make an act for every issue that arises. Okay, so now most of the acts that we've made are IPC, or you can say the Hindu Law Act and all of that. So they covered the basic issues that we deal in our daily lives. And one of the main disputes in our daily lives is the contract dispute, or the dispute that can arise when a legal relationship for trading is formed between two people. So in democracy, we form an act for everything that can be disputed on. Hence, we made the Contract Act. Now the Contract Act, as we know, is, as I've already mentioned, is a bread and butter law. So this defines what a contract is, this defines how the contract works, and this defines what can be the penalties if we breach a contract. So the most important thing that the Contract Act defines is when is a situation arises when a contract is formed, or what is a valid contract, or what are the essentials for forming a valid contract. So the first essential for forming a valid contract is an offer. That means one party to a contract, or one party to a contract in which there are many parties involved, needs to have an offer for a situation. We need to give an offer to a person that, for say, I want to sell this pen. So I put it in my shop, that I'm here to sell this pen. A person will come and say, give me the pen, I'll give you 10 rupees for it. So this is an offer that the other person is making. So the first and the foremost essential is there has to be an offer. The second essential is there has to be an acceptance for the said offer. Now the acceptance has to only be for the said offer. We cannot say that I decided to buy this pen, I give an offer of buying this pen, but and the shopkeeper sells me a scale. So there is an acceptance, there is a transaction, but it is not an entire contract. It will become a counter contract. For a contract to be a simple contract, there has to be acceptance for the said and the given offer. Both of these things have to be validly communicated. The offerer and the offeree have to know that there was an offer and there was a contract. There has to be no confusion in this offer and in this acceptance. and when there is no confusion, only then we can say that the communication for the said offer and the acceptance was clearly done. So now when this happens, we have to realize that there has to also be consideration. As we can see, this is a legal relationship that we are forming in the Contract Act. Okay, so now in a legal relationship, we say that there are no free lunches in life. So unless and until there is a consideration for the acceptance that we have made here, the contract does not fulfill. Now again, the condition for consideration is it has to be a legal consideration. We cannot say that please give me so and so thing for 1 gram of weed per se, or I will harm this person for you if you give me this house. So that is, there is an offer, there might be an acceptance, there might also be a consideration of cash or of kind or of a work that has to be done. But again, it is not a legal consideration, so we will not apply this as consideration. When all these things are fulfilled, this becomes an agreement. Agreement, like the word suggests, is I have agreed to do this and you have agreed to pay me for it. So this forms an agreement. And when this agreement, as we say, is enforceable by law, it becomes a contract according to section 2H of the Contract Act. So this basically is the flowchart of how a basic necessity or a basic essential for a Contracts Act has to be fulfilled. Thank you.